In many injury cases, and even more so in many employment cases, witnesses or even a single witness can be of critical importance to proving and winning your case. And this, of course, applies to both sides, to the plaintiffs and to the defendants. Let me give you a couple of common examples where witnesses can be very important to proving your case, both in injury cases and employment cases. And then I'll give you a few simple practical tips on how to better get those witnesses to testify for you, or if not testify, at least help you support your case. So let's talk about the common cases in the world of injury law where witnesses can be very useful or even crucial to proving your case. First scenario, a car accident. Both sides are claiming that the other side ran the red light at the intersection. Well, if you don't have any witnesses, often these cases are very hard to win. They're 50-50. Both sides have equal evidence or they have no evidence, and it's very hard to win this type of case. Most insurance companies, well, all insurance companies know it, and almost all lawyers know that, and that's why they don't like these types of cases. However, even if you have one witness, one good witness who saw the incident and who can with some degree of certainty say who ran the red light, it's going to be very helpful to one of the sides. Second example, a slip and fall case. Many companies, many defendants, many insurance carriers, they have inherent skepticism toward those types of claims. They believe that many of the claimants exaggerate the injuries, maybe they make up stories, maybe whoever says that they slipped or tripped and fell, they didn't even slip, they maybe fell for another reason, or they didn't fall at all and they just making things up. Now, if you don't have any witnesses to your fall, you might still have a decent case with sufficient evidence to prove your injuries and to prove what happened, maybe with pictures, with video footage. But if you don't have that, having even one witness on your side, someone who saw with their own eyes where you fell, how you fell, and why you fell, can be very useful to proving your slip and fall or trip and fall case. And the last classic example where witnesses are very important is any type of fight where you would get injured. Let's say you get punched or you get beaten up, and the other side is gonna say that either they didn't hit you or they didn't hit you as hard, or it was self-defense. You were the one who started the fight. If you have a witness who saw who started the fight, it's gonna make a huge difference. Otherwise, again, it's your word against the other side's word, and it's going to be very hard to prove who to believe in many cases. Let's talk about employment law. The common scenario would be a racial harassment or sexual harassment or age discrimination case where what your supervisor, what your manager did or said is going to make or break your case if you can prove it. Almost in every case, the employer is going to deny saying something harassing or discriminatory or doing something harassing or discriminatory. But if you have a witness who heard the decision maker say something harassing or discriminatory or do something harassing or discriminatory that supports your case, them coming into your case or them testifying or them submitting a declaration in support of your side of the story is going to be very useful to your case, and it can prove to make a difference between winning a case and losing that case. Now, here are a few tips on securing the witnesses and their testimony. Number one, ideally, you don't want to force anyone to testify under subpoena unless you really, really have to. If you have some friendly witnesses who would be willing to help you out, it's best to simply pick up the phone, be nice, and ask them to do that gesture for you. You could tell them that chances are that your case will settle like most cases do, but their testimony, even their written testimony, is going to be very helpful to you and very useful to proving your case. Sometimes people will not want to get involved. They just don't feel like it. They're too busy. They don't like the whole court system. They want to stay away. That's fine. ideally you would not want to be forcing anyone. If you want existing employees of the employer who you're suing to testify for you, many of them will be concerned about being retaliated against, and that is understandable. Ideally, unless you really, really need their testimony, ideally, you don't want to force them to testify, because in most cases, they're not going to say what you want them to say when they testify anyway. So you're going to subpoena them, they're going to come to deposition or trial. You're going to ask them, hey, have you heard my manager do this or say this? And they're just going to say no, no, no. So what good is that going to do? So ideally, you want your witnesses to be there because they want to help, not because you're forcing them with subpoenas. Secondly, when you talk to your potential witnesses to find out whether or not they have any useful information, it's better not to put words in their mouth. Instead of saying, isn't it true that I was terminated because of my race or because I complained about harassment? Ask an open-ended question to see what they know. Hey, have you heard anything about my termination? Have you heard anything about why I was demoted or why I was suspended? Hey, have you heard anything about my layoff? Was it a real layoff, or did they bring someone else in my place? And maybe there is more to the story. The same about car accidents or fights. Hey, did you see that fight? Did you see that car accident? What did you see? Who do you think was at fault? Why do you think that? Those types of open-ended questions will elicit a much more reliable testimony. You want your witness to tell the truth, and you want your witness to be able to articulate what they know based on their own experience rather than put words in their mouth, because it's gonna bring out better witnesses for you. So keep these simple tips in mind, and when you find a good witness, connect them with the attorney that you're talking to or that you already hired for your case. Maybe that attorney doesn't think you have much of a case. Maybe they took your case, but they have their own doubts and they think it's going to be hard. Send that email to your lawyer and say, hey, I found John Doe, here's his phone number, and he has this type of information that supports my side of the story, that supports my case. Please talk to him. Every lawyer will be very happy to have a witness that strengthens their case or strengthens your case. Thank you for watching.